live. This is Law Call.
And good evening, everyone. I hope all of the fathers had a great Father's Day out there today, and I hope everybody had a good night tonight. And glad you're with us. Here we are. It's 11:35. We're simulcasting on WMBB.com, WDHN in Houston County, Alabama, Dothan. And of course, we're Facebook Live, so you can get us anywhere in the country, anywhere in the world even. You can call us. We will take your questions live on the air, 850-392-1544. Or if you like, you can email us at lawcall@WMBB.com, and the producers will pass your email through to us. Tonight we're talking about estates, wills, trust, anything having to do with probate. We've got an excellent person here in the studio with us. His name is John Maslick. Let's go ahead and introduce John, and then we'll take our first email question. So John, if you don't mind, reintroduce yourself to the viewers. Some of the folks are up there in Dothan, Alabama. They might not have seen you before, so go ahead. The floor is yours.
I have been to Dothan, but I don't know that y'all have seen me on TV. Yeah, so yes, thanks, Larry. I'm John Maslick. I have a law firm. It's called Sunshine Legacy Law. And in that sense, we just try to do things that help you plan for the future, namely doing wills, trusts, creating living wills, powers of attorney, things like that that are going to help you get things in order so that you can rest easy, get on with your life, and then when the ultimate end comes, things move smoothly. So that's what we do.
Okay.
Yeah.
And John, you're a lifelong resident of Bay County, Florida, right?
That's right. That's right.
And one special thing, his father made me a father, and that sounds kind of strange in a sense, but John's father was an OBGYN, God rest his soul, and may his memory be a blessing to all of us.
Thank you, Larry.
And truly, I think that, you know, he went in, my wife was having some complications during pregnancy, and he saw her on a early Sunday morning and gave her a special shot and saved our child and made me a father, is like I say. So. Oh, somebody! Yeah, that's the somebody's in the garage there. It's bringing it in. Just let you know it's
Father's
live.
Day.
Yeah, happy Father's Day. So, you know, again, I've told you the story in private. Now I'm telling everyone out here. You know, without the benefit of your father, I don't know that I would be a father, and I truly appreciate what your father did for us.
Thank you, Larry. I appreciate that, and it's a blessing to be here with you as well. I know my dad would be proud to see me on here with you, and glad that he could help you all out.
Yeah, well, I appreciate it. Well, we're going to take our first email question here, folks. Let's go to that. A little bit off topic, but we can go over it just a little bit. And actually, I think you might have something to help out here. I own a rental house that was leased to a tenant who has had someone else living there. This other person invited a friend, so we've now got a second person in and their dog, and the dog bit the friend. It says their dog. I don't know if it's their dog meaning the first person or the second person, but anyways, the dog bit somebody. Yeah. The person bit is suing me as the landlord. I had no insurance on the house at the time. Oh, we need to talk about that. Otherwise, I would turn it over to the insurance company. I didn't see where any blame can be put on me, for I am not allowed in the house during the lease period. Please advise. And this is Brian. So Brian, kind of the first thing we want to talk with you about is if you have rental property, you need to take special precautions to protect yourself. If you have enough assets that you can set aside and have a rental property, probably the first thing you need to do is go out and get insurance. And of course, getting insurance after the fact is not going to help you in this particular instance, but it's something that would help you in the future. As far as the legal aspect of it, in all three states, Alabama, Georgia, and Florida, the landlord typically is not responsible for an animal bite that occurs on the property. And I say typical, there are some exceptions to it. However, the owner of the dog is strictly liable, meaning regardless kind of what happened, unless the dog was provoked, was being agitated in some way and then reached out and bit somebody to protect itself, then typically the person who has the vehicle, the person who has the dog is going to be responsible for the dog bite, and typically not the landowner. But you saw this question come up, John, and you also had another response that dovetails right into the show here. So
go ahead. A little bit. I like this because it's like a law school question.
It is, yes, it is.
Spot some issues is what you got to do.
A bar exam question, if you will.
That's it.
Yeah.
Even better. That's the one you really got to pass.
Right.
So the things that I thought about, and Larry touched on them about insurance. If you have rental property, what you really also want to do is probably have that in some sort of business legal entity like an LLC. It's going to give you a little added protection as well for these liability issues. And then beyond that, where we would come in is maybe you want to put that into a trust. something that's going to further protect you and your heirs and those kind of things going down the road. But that's something we can get into later.
I think so. So Brian, some advice for the future, and you know, it's something that you do need to seek an attorney about, because if you get sued and you don't answer that lawsuit, then you can be held liable for it. So if you do get lawsuit papers, you need to seek out the advice of an attorney immediately. We've got a caller on the line. Let's go to Ben, who has a question about a will. Ben, what's your question tonight?
Yes, we have a will, and we have a couple of lots of vacant land, and that's the only property other than our homestead. And we have a will that was prepared several years ago, and I've been told that it even with a personal representative to handle the will, that it has to go through probate. Is that true?
Yes, sir, Ben. Let me answer the question, and I'm going to kind of set you up here for Mr. Maslick, because I have another way to help you out that might get you to avoid probate. So, Ben, in a situation like this where there's property and it's in your name, and you mentioned you have a homestead, so if you're married and you pass away or your wife passes away, it automatically kind of melds in together. But these other properties, you may need to consider that, yes, that's going to be probated. However, there's something called a ladybird deed, and I'm going to have John talk about that ladybird deed and what that means and how that could be used to actually avoid the probate process. John?
Thanks, Larry. Yeah, so a ladybird deed is a really neat mechanism in the law. It allows you, specifically for your homestead property, you want to leave it to somebody already, and they're alive. They want to, obviously, they want to accept it. You can create a ladybird deed, which is just kind of the name that we use for it, but it creates a life estate for you. You get to stay on the property. You have use of the property. You can actually still control it and sell it if you want to prior to you passing away. But it does have a mechanism within the deed's language that it transfers upon your death. And if both you and your spouse are on there, it would be after both of y'all's passing, to that next person, the person who has the remainder estate in it, the claim, as it were. And that functions completely outside of probate, outside of any mechanism in the law. It's simply, you go down to the, I don't even know if it's the property appraiser or tax collector, and present that, you know, along with the death certificate. And they'll already know the deed's in there, and at that point it then is in their name. That's a pretty great thing to have.
Now let's talk about the vacant land, though.
Yes.
The vacant land is separate and different. Right. So how could Ben transfer the vacant land without having to go through probate?
Yeah, so the vacant land is another thing. Because it is you know, something that you own that's not easily transferable by title. You can do some other things with that as far as the deed goes. One of the ones that kind of covers everything and allows you to be a lot more functional in planning going forward is just create what we call a revocable living trust. Some of y'all just heard it as a trust. And basically you create that. It functions outside of probate when you pass to move everything that you've placed under the title of the trust. It moves then to whoever you say you want it to, separate from going to court, separate from the probate process. Unfortunately, if you have a will, and specifically for land, if you didn't have land and it was just personal items that you wanted to transfer, you could maybe avoid probate on those things. Cars are a good example. You can usually transfer those even if you have a will outside of the probate process. But land itself needs to go through that in order to get the court to order, this is the new owner. This is where the deed needs to be assigned to. But that trust is going to be a catch-all. It's a different way to plan for how you want to move things.
You know, and another idea too, Ben, and I don't know the size of it, and this is why you need to go talk with somebody like John so that you can sit down face-to-face with them and kind of go over this in somebody's office and ask the questions. The other way that I even consider doing is what you said in the first segment or the first question is set up an LLC.
Right.
And an LLC, you can have multiple members of the LLC, and then when one passes away based on the operating agreement, it's a transfer and that passes outside. So you got a couple of different ideas here that we've come up just on the fly. And so this is something that you need to sit down with an attorney and make sure that it's done properly. Ben brought up something though, probate. People want to try to avoid the big bear. Do I really have to go to probate and what that really means? Explain what the probate process is.
I think that's always good to kind of get a basic primer of what's going on here. Probate is the process of moving your assets after you've passed away over to the heirs that you've designated, either through your will, or if you don't have a will, the state has certain statutory kind of paths that you are going to have the inheritance go. It's usually to your first relatives, then down the line like that. But with your will, you get to kind of tell who you want to go to. When that happens, though, it does have to go to court. The judge supervises everything that's happening, whether it's going to be allowed or whether there's creditors that make claims, things like that. And, you know, the downside of being in court, you know this too, is public. You know, people can go down and pull the documents and look at it, or a lot of this stuff's available online. So that's the downside of probate. We always try to give the option is, like I mentioned just a minute ago, the trusts allow you to operate outside of probate.
Right.
And the big, there's a lot of different reasons people want to do it. One of them, just going backwards on what I just went over, is it's not public. Anything you have in there stays private between the parties that are involved. If somebody's not doing what you want, though, you wonder, well, how do I enforce this?
Well, then you go to court.
That's where the court comes in.
Right.
And they only come in for that one specific point, and that's dealt with. Whereas the probate, through the will, administering the will through probate, is all public, and it does have timelines, too. It can take a long time and potentially cost a lot of money.
Well, the minimum for an estate over, what is it, $25,000 or whatever it is for a standard estate in Florida is 180 days. Alabama, the minimum estate time is 180 days. And rarely do you get that 180-day mark, usually because of filings and objections and things that are going on. It could take a much longer period of time.
Oh, yeah.
And there's ways to avoid it. We've got Richard on the line. Richard, how can we help you this evening?
Well, I got a question, Larry. Just a minute ago, you mentioned Lady Bird. My wife passed away last October, September 27th. We signed documents with an enhanced life estate deed. Is that the same thing?
I don't know yet, Richard, and here's why.
Right.
You're talking about...
It could be.
It could be, and it sounds like it possibly could be.
Right.
But what do we need to do, John?
We got to see it.
That's right.
Yeah.
So, Richard, that is, even though you signed documents prior to her death, and I'm very sorry that she's passed away and no longer with us, we do need to see the documents. Actually, John would probably be the better guy to see the documents on this. And if so, that sounds like it is the same thing. He mentioned something called a life estate.
That's it, yeah.
And so that's what a Lady Bird deed is designed to do for the life of one or both parties that might be involved. But let's talk about what a life estate is. We're going to get deep in this tonight.
Oh, yeah.
What is the difference
like
between just kind of a standard estate and a life estate? What is that, John?
Well, and basically, it's almost a self-describes itself. It's something that continues on into someone else's life that's around. I mean, that's the easy way to look at it. And a life estate itself in this situation, and in your situation, we hope, is the enhanced life estate, means that there are other lives involved, not just the current owners. So you're looking at people you might be passing on to after the current owners have it. And it gives somebody an interest in that property. Now, when you do that also, they also may have some claims to it in the sense that they may not like what you're doing with it. And some types of deeds may give them powers to have a veto on whether or not you sell it or develop it or something like that. There's also the other side of the coin. It gives them potentially exposure to creditors. If that person does something, they may say, well, now we're going to attach their interest in that future deed to recover out of, which is a good thing in your case, but not always in our case.
But not in your case.
Yeah.
But that is all the more reason to sit down with somebody, not just Google ChatGPT. And by the way, I've done legal research with ChatGPT. It's awful.
It's entertaining, but not
it's entertaining, but don't follow it.
Entertainment only.
We've got a lot more to cover tonight, folks. We have to take a break right now, but we've had some great questions so far. The phone lines are open, 850-392-1544, and the email is available, lawcall@WMBB.com. Stay tuned. We'll be back in just a few moments. Folks, we've had some great questions so far tonight. We've got a few more waiting to be heard. So let's go to Jerry, who's on the line. Jerry, how can we help you this evening? You're Jerry? Okay. Jerry had a question. He was wanting to know, he said he had some land and he had some bank accounts, and he said, what is the best way to leave this to my biological daughter? So, John, why don't you take it away?
Yeah, so the easiest way, and we can go through all of them, and finding out the best way, we usually have to sit down with Jerry and talk with him to see how exactly is best to proceed. But the easiest way would be, we talked about the Ladybird deed. You got to go see a lawyer, draft up a new deed, sign it, file it with the property appraiser, or tax collector rather, and get that done. And that'll put her in that line to inherit the property, as it were, through the enhanced life estate that we just learned about, right? Okay, and then bank accounts are similar to that in that you can go down to the bank usually, and almost every time when they have you open these accounts, they ask you who do you have on the account, who's has authority to sign. If she's not on there now, you can go down there and add her and make her a joint owner of the account. Now, there's a couple different ways to do that. Banks they have their specific ways they like to do it. So you have to talk to your bank, see what they want to do. But at that point, that money is also hers. And again, that brings in other legal issues. But those are two things you can do that are quick, can take care of it next week, right? There are other ways that we as lawyers would probably talk to you about that are a little more thorough, offer you a lot more protections, would involve an actual will, maybe some trust planning, things like that, and creating other documents that we can get to in a little bit that are outside of a will that just help you deal with your life as you're even still alive on things.
Now, you brought up a point though. If Jerry goes ahead and titles these bank accounts in his daughter's account with her name on there, with his, I mean, I hope he trusts his daughter, right?
Right, that's right.
And because of the new banking regulations and the new banking laws, she has to know about it. She has to go down and sign. She has to give her social security number. She has to give her identification as well. So it's not something that Jerry could just do and then when he passes away, she gets it. She has to be actively involved in it.
Right.
But there's another way to do it too. I mean, you can, as you said, you can set up, depending on the amount of money involved, you can set up a revocable living trust. And then you can name her as the successor of these particular accounts.
Right.
You retitle the accounts in the name of the trust instead of Jerry's name.
Right.
Oh, I'm good at this.
He's got it all. I don't have to chime in.
Yeah. So I mean, so really, is that?
That's right.
So that's a way to do it. And by doing it that way, he still maintains 100% control over it.
Still maintain all control
with a legal or a living trust or revocable living trust.
Right.
But if he just puts her name on it, he then loses 100% control over it.
Right.
And if daughter is a ne'er-do-well, spendthrift, decides she likes the new car.
A bad boyfriend that
says,
hey, go withdraw that money and let's go on a trip.
Bad money, man. Bad money gets you in trouble all the time.
Yeah, so, yeah.
So, Jerry, even though we've given you some simple ways to do it, it really is best to sit down with somebody like John, pay for the hour's consultation, go ahead and get it taken care of. Make sure it meets your needs, make sure it meets your daughter's needs. Either way, there are multiple ways to avoid the probate process. Just make sure that it's done correctly and done right. One of the great, speaking of people who, even though they have a great legal mind, doing it the wrong way, Chief Justice Berger, U.S. Supreme Court, writes out his own will and messes it up. You don't know this story? Oh my goodness. Created a legal battle that lasted nearly 20 years.
My goodness.
Chief Justice Berger. So the United States Supreme Court Justice, even though, supposedly, the highest court in the land, Chief Justice, highest judge in the land, writes out his own will, and and it's called a holographic will if you write out your own will. Failed to, follow certain protocols that somebody like John would know.
Probably, and, simple stuff. Right?
And certainly, instead of passing it very easily, ended up, a 20-year legal battle as a result. Let me go to something though. All right, this. We got Susan on the line. Hold on just a moment. I just got to say this though. Please, please, please do not use Google. Do not use ChatGPT to write your will.
Right.
Do not do it. Go see a lawyer. It is the worst thing in the world to get a form and I've got one in my office right now that's involving litigation. They went and got a form and they formed it up. And you can imagine what the other four-letter word is that's there. They really messed it up. And so even though the form is there and the form is free or costs $5 or $10, don't do it. Go talk with a lawyer.
You
go
get
talk
what you
with a
pay
lawyer.
for sometimes.
Well, yes, you do.
Times, right?
Yes, you do. But please,
Only
go talk to
$10
somebody.
worth of law.
I'm
It's not
saying
good.
this, screaming from the rooftops, hallelujah, Jesus, let me tell you something. People have made some mistakes.
Yep.
And I wish there was something that I could do to go back and change them. They're calling me with the mistakes, and that obviously means more money. We've got a caller on the line. Who do we have? We've got Susan. Susan, how can we help you this evening?
Yes, now I'm kind of questioning the ladybird deeds. I had filled some out years ago or had them filled out for my son to have his name included on some properties that I have. Now I'm wondering if he did anything that created liabilities on himself, could those properties be held in any sort of, could I be in problems with them even though they're free and clear and have no liens or encumbrances?
Yeah.
If he did anything that was, like on a car accident or whatever, could they possibly come against those assets?
Yes.
This is the perfect show to call.
This is the perfect show.
Tonight.
And the
Yes.
short answer is yes, and I'll let John take it from there.
Well, and I'm going to bounce back to you on the auto accident side of it. But the short answer is yes, and it also depends on obviously how the deed is written, because it can put limitations on his interests, which then protects the property. You know, if it makes it unique, that it is not something that he can put liens against, things like that. Most of the time, you can't. You can't, as a future owner, go and borrow against it. There's not many people are going to allow that. You know, banks are usually a little smarter than that. A loan shark, I don't know, maybe a different thing, but there you go. That might get you in those kind of troubles. But that's that issue. As far as future claims for current injuries, I don't think that's going to be an issue either, but you can answer that a lot better than I could.
It doesn't directly attach to the property, but it attaches to the person.
Right.
And you start changing these things, then somebody like my firm would say that's a fraudulent transfer, and now you've got issues.
Right.
And so there are other ways to do it, Susan. And again, sit down with John. It sounds like you got forms from somebody, heard that it was a good idea. Let's make sure that it's a good idea. Don't come see me, come see somebody like John. And let's make sure. There are ways and provisions to do it. And we want to make sure that you're protected in doing that. That's the idea behind shows like this, is to educate folks, bring things to the forefront, see the things that we're seeing in our law offices, because things that we're seeing in our law offices, we know that you've got questions about, and hopefully we can provide some education and guidance and direction in that. Folks, we need to take a break. It's gone by so quick tonight.
Really quick.
The phone lines are still open, 850-392-1544. Give us a ring. We'll be right back. Everyone, we have had a great evening tonight. We've actually got several calls on the line. We promise that we'll give you a call tomorrow. Either my office or John's office will give you a call. We have just run out of time tonight. We've got some shout outs to go through tonight. Let me kind of go through some of mine. I was told to say go Gators. I hate saying that, but go Gators, and you know, go Tigers as well from my group out there in LSU. Chuck Geroloman, I believe it is an assistant coach and is also related to one of my paralegals. That's why I had to do that. I've got Julie, I got Gary, I got Harriet and King watching tonight. I got Patty Lynn, I've got Gigi, the Cookie Monster. I've got Lucy, her mother and grandmother watching. Hi, Lucy and Grandma and Ma. I'm glad everybody's watching tonight. I got a couple of photographs of things that have taken place over the past week. There we go. Mr. Fernandez made a beautiful flan. That was the best flan I've ever had, Mr. Fernandez. Thank you so much. We've had lunch with Larry, so this is Cindy Schwartz, which was brunch with Larry at Andy's Flower Power. We're going to talk about that on Facebook this week. We've got Abby and Allison and her mother. They wanted Enzo's Pizza. We got that. Got to remind everybody about the Panhandle Watermelon Festival this weekend in Chipley. It's a free event. We've got Rennie, who graduated from kindergarten this time. Congrats. And of course, we've got Sarah and Wade. Sarah is celebrating 1 year of kicking cancer's rear end. You got a couple shout outs there as well.
Yeah, real quick, we'll say to Mom, Molly Murphy. Michelle, went to high school with her. Rachel over on West End. Alan, and Keith and Nadia over there in Freeport.
Folks, thank you all for watching. We'll be back here this same time, same station next week. Stay tuned next week for Law Call. Y'all have a great week.